Good morning, my dear guys and dolls. Today I propose to deliberate there are different forms of protections, and today I propose to deliberate those very forms of refugee protection. We are going to deliberate, discuss, and delineate temporary protection, situations of temporary protection, dimensions of temporary protection, implications and ramifications of temporary protection which is available to refugees under international refugee law. We have to deliberate in the context of temporary protection, state practices, how temporary protection has been extended to refugees, to asylum seekers, even within the nation states in their domestic jurisdictions, what kind of a protection is available and generally made available by the national governments to some other persons or other people, displaced people, and forced migrants within the national jurisdictions. We are also going to deliberate, my dear friends, complementary protection, subsidiary protection, and entire canvas of different kind of protections which are available to refugees. At the same time, we are going to deliberate the future of international protection for refugees and forced migrants under international refugee law. We have to deliberate, my dear friends, further the concept of temporary protection, refugee protection in situations of the mass influx, prima facie status we have to determine in the context of temporary asylum, grounds for temporary protection in international law and state practices. We have to appreciate on critical footing the relationship between temporary protection, subsidiary protection, and the problems related to the granting of temporary protection and the adoption of a temporary protection framework in different what we call nation states, particularly in Bangladesh, in Turkey, and some of the European nation states. We have to take into account, my dear friends, certain important issues relating to readmission agreements, cooperation, border control, and responsibility sharing or the burden sharing, and during the situations of armed conflict and the standard proof in complementary protection claims. We have to take into account what exactly has been the impact of 9/11 so far the temporary protection is concerned. We have to take into account United Nations High Commissioner for Refugees and the purposive approach to treaty interpretation in this particular connection. So there are certain important questions which we should try to understand. But before I get down to certain important and relevant questions in this connection, it is equally important, my dear friends, then we have to take into account certain important legal instruments. Particularly, I am talking of the core instruments and documents on temporary protection, namely United Nations guidelines on temporary protection or stay arrangements. We have to take into account, my dear friends, 1967 UN Declaration on Territorial Asylum, as I have already submitted on this particular declaration. We have to take into account 1984 Torture Convention, United Nations, Convention Against Torture. We have to take into account the playing human pinball, this kind of a paper that was presented in 1995 by the Amnesty International. Then we have to take into account, my dear friends, the United Nations Office for the Coordination of Humanitarian Affairs Guiding Principles on Internal Displacement of 1998, which we have considerably and significantly deliberated in our earlier what we call engagements. Thereafter, my dear friends, we have to take into account certain specific articles of Refugee Convention of 1951, particularly I am talking of Article 5, Article 8, and Article 9 of 1951 UN Convention, then we have to again take into account Article 5, where it has been stated, my dear friends, that nothing in the convention, I mean the 1951 convention, shall be deemed to impair any rights and benefits particularly granted by a contracting state to refugees, apart from what we call, other forms of, protections. On this particular point, my dear friends, it is equally important to deliberate to some of the important, cases which I am going to share with all of you, and that is Tahir Hussain Khan versus Canada. That is a decision on temporary protection delivered in 1994, particularly by the Committee Against, Torture under the 1984, Torture Convention. Then Chehel versus United Kingdom, that is again a decision of 1996, where the violation of Article 3 of the European Convention for the Protection of Human Rights and Fundamental Freedoms was appreciated on critical footing. Then again, there is another important decision delivered by the Supreme Court of Canada in 1993, that is Attorney General versus Ward. In this particular decision, we have to try to understand different what we call implications regarding the rights and freedoms for individuals if they are what we call denied because of their migration. Then Horvath versus Secretary of State for the Home Department, again this is a decision of the 2001 which we have to deliberate. But here lies another important what we call question, and that is, what is temporary protection? How should we try to define this particular protection? This is the most important and tricky deliberation which we are going to unearth. We have to what we call decipher. But before I what we call take into account the idea of temporary protection, we should not forget, my dear friends, the different what we call periods where various refugees arrived in different geopolitical entities. Suppose you can take the example of 1994 up to 1918. We have been confronted with the arrival of the Belgian refugees. And in 1920s, my dear friends, there were Russian and Armenian refugees. Then from 1930s to 1940s, we have witnessed the arrival or the emergence of the Jewish refugees. Then from 40s to 50s, Eastern European refugees ultimately flooded various geopolitical entities. And from 1960s up to 1980s, my dear friends, Vietnam, Chile, Uganda, Asians, Eastern what we call European nation states also confronted various what we call groups of mass, or rather I should say the mass influx of refugees in their territories. Then I take you to another important decade, that is 1990s. We have confronted the entire community of nation states confronted with the arrival of the refugees from Kosovo, Somalia, Iraq, Iran, Sierra Leone, Congo, Ethiopia, Rwanda. And then it is, from 2000 to 2020, we have also witnessed again the refugees coming from, Afghanistan, Syria, Iraq, Iran, Eritrea, Zimbabwe, Central African Republic, Middle East, China, Myanmar, Somalia, again Congo, Mexico, and Venezuela. And right now, my dear friends, from 2021 up to 2022, currently, we have also been what we call, witnessing the new influx of refugees from Eritrea, Sudan, South Sudan, and the latest one happens to be the Ukraine. So this is the entire what we call, canvas. And we have been, witnessing the mass influx. Then again, we have been witnessing mass re-influx. We have been witnessing exodus of refugees. We have been, witnessing the re-exodus of, refugees, migration, transmigration, re-transmigration, very well. A complete what we call, cycle and recycling of refugees has also been what we call, taking place. And this is how the entire what we call, planet Earth is currently confronted with the, arrival and re-arrival of what we call, refugees, migrants. Then here are some of the most important tricky questions which must also be taken into account. Suppose, how powerful is international law in the field of refugee protection? That is the most robust, tricky, and very challenging question. What are the grounds for temporary protection in international refugee law and state practice? That has to be taken into account. How to appreciate, my dear friends, the relationship between temporary protection, subsidiary protection, and refugee status? That has to be cajoled. How to identify the main strengths and weaknesses of the current international regime in ensuring implementation of the protection framework? Are the concepts of the temporary protection and safe haven a supplement or a substitute for refugee protection as traditionally conceived? What is the future of refugee protection, my dear friends? Can we think of humanitarian law, refugee law, and human rights law as three overlapping circles of international protection for victims of conflict, victims of persecution, and victims of oppression? What are the significant differences or potential tensions between the three frameworks, and how might they complement or reinforce one another? That is the most important question which we have been deliberating ever since we have started our engagement in this particular field of study, and that is international refugee law. My dear friends, is it protection or is it a deterrence? What other options exist? Are the concepts of temporary protection and safe haven a supplement or a substitute for refugee protection? What new global problems impinge on current models and frameworks of refugee protection? The result of a free market in asylum seeking can only be what you call, guessed at. What other alternatives are there? Are environmentally displaced persons refugees? Are they legally entitled to international protection? What kind of a framework is available for their what we call protection? Then what exactly should be the contours of the temporary protection? Let us ponder over. Let us mule over, my dear friends. My dear brothers and sisters, the 1951 UN Convention relating to the status of refugees, and now I am going to call it a Refugee Convention, and other associated what we call standards may be seen as critical elements of liberal internationalist aspirations, dreams, and goals for universal human rights and protection, particularly in the post-Second World War scenario. My dear friends, the standards which have been encapsulated in Refugee Convention are primarily based on the principle that justice as a dimension of citizenship rights needs to be extended to a global sphere rather than remain confined within the boundaries of a nation state or a particular geopolitical entity. Therefore, globalization is seen to have shifted the role of state, posed challenges to its power from global markets, intergovernmental organizations, and non-governmental organizations underestimating macroeconomic management, that is increasing public insecurity and reasserting of the politics of the border. It is the politics of the national boundaries that is basically determining the immigration implications and the citizenship rights. The attempt by the Western governments, my dear friends, to deter, detain, and deport those entering through the back door is seen by some as a move away from a rights-based what we call liberal internationalism towards exclusionary nationalism or a particularist internationalism which redefines asylum as a political what we call benefit bestowed by the host state rather than a human rights involved and accessed by individuals irrespective of their mode of what we call entry. Dear friends, the refugees are inherently temporary and their status as refugees exists to bridge the gap triggered by a collapse of the natural or national what we call bond between citizen and state. And nobody can deny this particular line of inquiry. The refugees seek temporary protection, my dear friends, in another state under international refugee law until such bond can be restored, either with the country of nationality or with the third state. Temporary protection, my dear friends, is metaphorically speaking, that is similar to immediate or at emergency medical first aid to refugees upon their hinting the land of what we call of reception in the absence of the full protection with a wide range of rights and benefits under the 1951 UN Convention relating to the status of refugees, particularly in the mass influx situations or otherwise. You may also invoke. The claim for temporary protection, therefore, is an inclusion in a host territory or country or community, or as a consequence or as a result of exclusion from national protection of the territory, country, or society of the state of origin or state of nationality or their homeland or homeland of the refugees. My dear friends, temporary protection is a backup to the full protection one expects from the state that come into play only in situations when such protection of country of origin is not available. Therefore, temporary protection is a continuation of insecurity and the deprivation of rights and benefits outside the 1951 Refugee Convention. Therefore, United Nations High Commissioner for Refugees has issued a note on international protection in 1994, my dear friends. And I am not exactly in a position to reproduce the exact language of that very note, but in essence, I should say temporary protection was conceived as a return-oriented protection mechanism within which the focus on return as the most appropriate what we call solution has been what we call located, provided, particularly the rationale for standards of treatment which emphasize the provisional aspect of the refugees stay and what we call minimize, at least in the initial stage, efforts to promote integration. So this was the gist of that very what we call note that was provided in 1994. United Nations High Commissioner for Refugees, again, my dear friends, in the same note has also emphasized a broad consensus must be achieved to provide protection, including asylum, on at least on temporary basis. Temporary basis, particularly to refugees who have been compelled to flee war or serious civil disorders, as well as those what we call running from persecution. And it also what we call suggest, my dear friends, the adoption of guiding principles embodied in a global regional declaration. Whatever the protections are available at international level, at regional level, at what we call national level, each and every aspect of the protection available on temporary what we call context must be invoked under all circumstances. Such as, my dear friends, if you take into account the entire semantics, entire idea of temporary protection, and what kind of a message, or in other words, let me put it like this, if we are going to further study and try to draw some kind of a consequential inference from this particular note on international protection issued by the United Nations High Commissioner for Refugees, it is a symptomatic of the ambiguity which endured throughout the what we call decade, or various what we call decades, ever since it has been issued, regarding the personal scope of the temporary protection. My dear friends, United Nations High Commissioner for Refugees would recommend a non-binding declaration to address the needs of the refugees fleeing persecution, is to say the least odd, given that these refugees fall within the scope of 1951 UN Convention relating to the status of refugees. Now, after deliberating or having said all these dimensions and putting them for your consideration, here lies a very, very important question which I have asked at the initial stage of my submissions. And that is, What is temporary protection? My dear friends, the concept of temporary protection has evolved in Europe and other regions as a provisional protection. Provisional protection responds to situations of large scale displacement generated to a significant extent by compelling reasons, including or similar to those in the refugee definition, which has been incorporated in 1951 convention. The purpose of temporary protection, my dear friends, is to ensure immediate access to safety and protection of basic human rights, including protection from refoulement, protection from persecution, protection from violation of human rights, protection from foreign occupation, protection from foreign aggression, and particularly in those what we call countries directly affected by large scale influx. Therefore, temporary protection may also serve to enhance the prospects for a coherent regional response beyond the immediately affected area. The United Nations High Commissioner for Refugees, the Council of European Union, the European Council on Refugees and Exiles, and refugee advocates, my dear friends, generally align on the optional what we call, or rather I should say, optimally on the scope, use, and characteristics of the temporary protection programs. And in one of my submissions, my dear friends, long back, I think that was published in 2016 or 2017, I have also talked of temporary protection to refugees coming from what we call Myanmar, particularly in the context of Syrian refugees in India and the Rohingya refugees in India. So I also advocated in that particular blog the idea of temporary protection, because the temporary protection is generally associated with protection of limited duration and standards of treatments lower than those which have been contemplated and envisioned in 1951 UN Convention relating to the status of refugees. In some mass influx situations, refugee convention rights have been suspending pending the resolution of the cause of such movement. Therefore, the United Nations High Commissioner for Refugees, or UNHCR, has both acknowledged and called for temporary protection in such situations, including in respect of state parties to 1951 Refugee Convention, and therefore, my dear friends, for persons who would customarily benefit from convention protection. Therefore, the Executive Committee of the High Commissioner's Program recommends temporary protection as the minimum protection every asylum seeker should receive in the country of what we call reception. And this is the line of argument which I have been advocating. The temporary protection program, my dear friends, should not be used as a substitute to refugee status, or to delay a grant of refugee status, or to deter and deny entry to those seeking protection, because that is a violation of international refugee law. That is a violation of Article 28, Article 29, Article 30, and Article 31 of the 1951 Refugee Convention. Because the temporary protection, my dear friends, or the temporary protection programs should be utilized to protect persons who are in substantial peril and who do not meet the refugee standards and who cannot avail themselves of the refugee determination, what we call, procedures. So therefore, it becomes necessary to extend the idea of what we call the temporary protection. European Council, for example, the European Council Directive on Minimum Standards for Giving Temporary Protection conceives of temporary protection as a what we call procedure to use in situations of the mass influx, imminent mass influx, particularly if the asylum system cannot process the influx without adverse impact of its what we call efficient operations. This has been what we call adumbrated in the European what we call Council Directive in 2001, and that takes into account, if you take into account Article 2 subclause A of this European directive, you will find that this has to be what we call, utilized in situations of the mass influx. Temporary. The word temporary, in fact, my dear friends, might better be characterized as impermanent. Therefore, for this very reason, my dear friends, European Council requires that beneficiaries of the subsidiary protection receives a roughly equal treatment to refugee what you call protection, and it has been stated in one of the most important what you call article on this particular most important directive issued by the European Council in 2011. Therefore, a long-standing question that has been provoked by the granting of temporary protection instead of the convention rights in such situations, whether states parties to 1951 Refugee Convention can justify as a matter of law, rather than what you call any kind of a political pragmatism, suspending convention rights to asylum seekers and or refugees in mass influxes. Even though the 1951 UN Refugee Convention does not include a general derogation clause equivalent to those in international human rights treaties, it is argued, my dear friends, the two provisions of the convention, Articles 8 and 9, nonetheless provide for derogation. In the alternative, it is posited that via subsequent agreement of state parties, implied derogation allowing for temporary protection in mass influx situation is now in accepted features of the convention or 1951 convention refugee rights regime. Even in recognizing the legal power to derogate from the convention rights in mass influx situations, there are limits on derogation under international law, and these limits equally apply to derogation under 1951 Refugee Convention. Therefore, my dear friends, we are having various temporary protection instruments in addition to 1951 Refugee Convention. In case of soft law, my dear friends, we are having conclusion on the provisions of international protection, including through complementary form of protection, and that has also been what we call issued in 2005, which is popularly known as the EXCOM Conclusion 2005. We are also having general conclusions on international protection of 1994, which is also known as EXCOM Conclusions of 1994. We are also having so far another instrument of a soft law nature is concerned, protection of asylum seekers in situations of the large scale influx of 1981. This is popularly known as the EXCOM conclusions of 1981. Then we are also having United Nations High Commissioner for Refugees documents on temporary protection. We are also having the case laws, particularly the cases which have been decided by the European Court of Human Rights, European Court of Justice, and Inter-American System of Human Rights, or other African Union regional judicial courts, and we are also having the national judiciaries so far the temporary protection to refugees is concerned, including the South Asian jurisdictions or the South Asian judiciaries. We are also having certain important regional arrangements at European level, at Inter-American level, at African level, so far temporary protection is concerned. We are also having national legal, what we call, national legislations, I should say, national legal regimes for the protection or providing temporary protection. And at the same time, we should not forget, my dear friends, the idea of juristic writings, because the juristic writings has also provided a lot of mechanisms for the temporary protection, and that should not be forgotten. So what is the, what should be done? What is the debate? What is the discourse? And what are the contours of this kind of a debate? Or exactly, let me put it like this, what exactly is the central debate when we are, talking of temporary protection? Is temporary protection, my dear friends, on the basis of the group, what you call, assessment of protection, need an adequate alternative to individualized examination of the refugee status? Are there legally binding norms for temporary protection, or is it a matter of discretionary state practice? How should we visit it? What should be the duration of temporary protection? What level of rights must be accorded to those granted temporary protection? Is temporary protection, my dear friends, under ultimate analysis, a useful vehicle for achieving refugee law or advancing refugee law or enhancing the protection thresholds of international refugee law? Is it the tool states need in order to resolve contradictions, paradoxes of protection, or inherent contradictions of protections? Or how to bridge the gaps which have been identified and how to correct weaknesses in exempt what you call or exempt international law on temporary protection that has to be taken into account. Another important dimensions that is agitating my mind, and that is, can temporary protection, my dear friends, be the basis for a supplement, or in a more what you call daring spirit, I should come out or speak, should temporary protection be the contemporary alternative to 1951 Refugee Convention rights and whatever the thresholds of the protection that has been envisioned and contemplated under this particular convention? Therefore, we have to identify, my dear friends, if we are really interested to understand this debate of the temporary protection, we must gather certain important focal points, the nodal points, the most central and pivotal points. And what are those points? Number one, we should try to understand, my dear friends, temporary protection as an administrative measure until individual examination is carried out or group recognition occurs. That is the point number one, based on administrative measures. Temporary protection, the second important point, temporary protection must also be addressed and recognized, regarded as a precursor, my dear friends, not as an alternative to 1951 Refugee Convention. At the same time, number three, my dear friends, temporary protection does not suspend states' duties under the 1951 UN Convention relating to the status of refugees. Therefore, number five, or fifthly speaking, my dear friends, temporary protection should not become a substitute for the rights of refugees to seek and enjoy asylum in accordance with the internationally agreed obligations, standards, and norms. This is how we should try to understand idea of temporary protection, and so far its vital points are concerned. Therefore, my dear friends, if we are really interested to understand the concept of the temporary protection, if we are really interested to address this very question, what is temporary protection, if we are really interested to conceptualize the idea of temporary protection, then we should try to understand that the temporary protection is widely regarded as an international legal norm. Then only we can address this idea of temporary protection, because the temporary protection is now obligatory in certain circumstances on states with regard to their treatment of a mass influx of refugees or of persons fleeing situations of armed conflict or civil strife, as we are witnessing the confrontation between what we call Russian Federation and Ukraine, and that has generated a lot of Ukrainian refugees. So the temporary or what kind of or specific circumstances have also been created, and the neighboring states are under an obligation to extend this a very humanitarian treatment of a mass influx of what we call of Ukrainian refugees or Ukrainian people fleeing situations of armed conflict. As a recognized what we call status, it is the most recent of what we call of three major possibilities for protection of the refugees a state can offer. The other two being the now universal obligation of non-refoulement, as we have witnessed in case of Rohingya refugees in Bangladesh, and in the neighboring countries in case of Ukrainian refugees, and the non-obligatory protection of political asylum, as various what we call people and the political leaders have been granted asylum in many of the geopolitical entities, particularly in the western what we call capitals. Therefore, my dear friends, temporary protection termination as a prelude to repatriation involves issues analogous to those that arise under Article 1C subclause 5 of 1951 UN Convention relating to the status of refugees. We can say at this stage, my dear friends, so far the understanding of temporary protection is concerned. We can also attempt to have some kind of a definition of the temporary protection in these circumstances. Temporary protection, therefore, my dear friend, has no accepted what we call meaning under international law or under international refugee law or under international human rights law or under international humanitarian law. Therefore, temporary protection has acquired multiple and varied what we call meanings and context depending on the situations and the country. Temporary protection is a concept, my dear friends, commonly used to describe a short-term emergency response to a mass influx of asylum seekers. Therefore, temporary protection has also been applied in situations where it is difficult to distinguish between asylum seekers and other moving mixed what we call flows, as well as to broader what we call categories of persons who fall outside the 1951 UN Convention definition of a refugee. Therefore, the term is often utilized, often employed interchangeably with the temporary asylum, temporary refuge, and other what we call similar expressions. This reminds me of a very, very important jurist, a very prolific writer on temporary protection, particularly in entire what we call refugee law. I am talking of Coles, Coles. Coles rightly pointed out in his writings in the late what we call 80s, and he preferred a temporary refuge to temporary asylum. Largely because why he has preferred temporary refuge to temporary what we call asylum, it was because he argued it avoids the confusion with asylum, which he notes is not agreed, while containing the notion of protection. Coles therefore defined, my dear friends, the idea of temporary protection or temporary refuge as that protection characterized by the principle of non-refoulement, which is accorded a person and which is temporary pending the obtaining of a durable solution. Likewise, another important jurist, Hartman, has also what we call came out with his idea of understanding regarding temporary protection, and that is he equated basically, my dear friends, again in the 80s, he equated the idea of temporary refuge as it has been coined by Coles with the traditional refugee law concept of non-refoulement, in that it consists of essentially of a ban on forced what we call repatriation of civilian war what we call victims, and also what we call notes that its temporal limits are determined by the duration of the armed conflict, which can persist for extended periods or flare only what we call briefly, or that can be extended to a very limited period of time. Hartman also argued, my dear friends, that the temporary refuge has crystallized into a customary international law norm. At the same time, he argued that the practice of granting sanctuary to civilian war victims is well documented and impressive in its consistency and extent. So far, its attainment of the status that is equivalent to customary international law principles. The focus of Hartman has been, however, circumscribed around non-refoulement obligations, whereas many modern temporary protection arrangements also include some form of rights, what we call availability, enjoyment, and exercise. If you take into account, my dear friends, the language of the temporary protection emerged in 1990s, and that has also what we call, established a paradigmatic, shift in language from refuge to protection appears to have coincided with the transition in the meaning of international protection that also took place at the same what we call, time. If you take into account subsequent, transitions, that those transitions have also witnessed, my dear friends, a focus on diplomatic protection to a broader, concept of international protection, and it also involved human rights or surrogate protection. Likewise, my dear friends, temporary protection appeared to move beyond Coles or Hartman's what he called the idea or the concept of non-refoulement obligation to other limited what he call, human rights. Therefore, we can say that the United Nations High Commissioner for Refugees 1994 note on international protection, which I have already submitted, is considered to be the best what we call, guarantee so far temporary protection as a means in situations of the mass outflows for providing refuge to groups or categories of persons recognized to be in what we call, necessity or used of international protections without any kind of recourse, at least initially, to individual refugee status determination. So it becomes necessary, my dear friends, to invoke whatever the situations have been contemplated in this particular United Nations High Commissioner's note of 1994 on international temporary protection. In 2001, again, my dear friends, United Nations High Commissioner for Refugees refocused on the influx and reiterated its view of temporary protection, because United Nations High Commissioner for Refugees basically conceptualized temporary protection as a practical device for meeting urgent and emergency protection needs in situations of mass influx. UNHCR values or temporary protection value in ensuring protection from refoulement and basic minimum treatment in accordance with the international human rights treaty obligations without overburdening individual status determination procedures, which has not been properly demonstrated in situations of the mass influx. Therefore, in this particular context, in this particular description, or in this particular depiction, United Nations High Commissioner for Refugees acknowledged that the temporary protection can be applied to convention refugees in emergency situations, and it also permitted, my dear friends, the suspension of both status determination procedure or RSD procedures and the full range of convention rights, 1951 UN Convention on Refugees' Rights. Therefore, United Nations High Commissioner for Refugees has never elaborated the legal rather than the practical humanitarian basis for such kind of a what we call of protection, suspension of the protection, or other important what we call situations. Therefore, if you take into account further, my dear friends, so far the definition of the temporary protection is concerned, we should try to visit the European Union Temporary Protection Directive, and that has been issued, as I have already submitted, in 2001. And this procedure has also highlighted, my dear friends, a very, very important definition. An attempt has been made to define. I'm not able to reproduce the exact language of that very definition that has been, but I still remember the gist of that very definition, because European Union Temporary Protection Directive says a procedure of exceptional character to provide in the event of a mass influx or imminent mass influx or potential mass influx of the displaced persons from third countries who are not in a position to return to their country of origin, to their country of what we call of nationality, or their country of what we call of, or the country of homeland. Immediate and temporary protection must be extended to such kind of, displaced people who are fleeing particularly if there is also a risk that the asylum system will be unable to process this influx without adverse what you call impact for the efficient operation or for other important circumstances, or the people who are fleeing from violence, generalized violence on a large scale, as well as they are fleeing persecution exclusively based on the political opinion because of the membership of a particular social group, and that is going to be in the interest of the persons concerned and other persons requesting or seeking any kind of temporary protection that should immediately be granted to them. Therefore, temporary protection as a response to mass influx situations involving convention what we call refugees. But it has to be, my dear friends, that when I am using the word mass influx, then it is not a term of art. It is generally understood to entail, my dear friends, to convey considerable number of persons arriving, particularly over an international what we call border. A rapid rate of what we call of arrival has to be recorded. Inadequate absorptions or response capacity in host what we call states, that has to be taken into consideration, particularly during the emergency what we call phase, and individual asylum procedures where they exist are not in a position, not or does not have the wherewithal to deal with the assessment of such kind of a large number of what we call of influx of refugees. In that very sense, we try to what we call resort to this kind of expression, which is known as, within inverted commas, as mass influx. Therefore, there is neither a minimum number nor speed of what we call of arrival to understand this particular expression, a mass influx. The last element which I would like to what we call submit for your perusal, for your consideration in this kind of a situation, is that the integration capacity of the national asylum systems. And the last element that has been what we call said to add an important qualitative dimension, making it impossible, my dear friends, and indeed undesirable, I should say, to establish in precise quantitative terms how large or sudden or refugee what we call flow must be in order to be characterized as mass influx what we call situation that has to be taken into consideration. With the entry, my dear friends, with the entry in force, I should say, or into force of the Refugee Convention, 1951 Refugee Convention I'm talking of, and the establishment of this what we call UNHCR, the international legal norms impacting adversely what we call impacting bilateral and multilateral arrangements concerning refugee shifted in a number of significant what we call manners, ways. Number one, first of all, the prior practice of recognizing refugees as group or categories changed to an individualized assessment of whether a person qualified as a refugee under a specific case-by-case definition. Number two, the Refugee Convention of 1951, if you take into account its definition, the definition was intended to be ideologically neutral. But this is not true if we take into account the perception that has been expressed by the global South geopolitical entities. However, as an objective definition, as it has been adumbrated in the schematization of 1951 Refugee Convention, that would view refugee determination on a non-political basis. But nothing moves without any kind of a politics so far international crises are concerned, and refugee crisis is one of them. The Refugee Convention, therefore, my dear friends, brought about a new focus on international responsibility sharing of refugee flows, moving away from the prior focus on refugees as a solely regional or bilateral problem. And in the same line of argument, my dear friends, I can also cite the recent conclusion in 2018 UN Global Compact on Refugees and Migrants under 2016 New York Declaration on Refugees and Migrants. idea of responsibility sharing has been strengthened. But prior to the 2016, this idea of responsibility sharing was not there. Rather, it was branded as burden sharing. Therefore, if you take into account the executive committee of the High Commissioners program, which is popularly known as the XCOM, was established as the entity that would provide the mechanism for determining how and such international responsibility towards the refugees would be shared. With this regime in operation, or with the emplacement of this kind of a regime, the international community initiated a consensus, initiated or started driving a consensus model of refugee protection or refugee problem, what we call palliation, sharing the responsibility of implementing a multi-level durable solution process driven by pivotal principles of the refugee choice that has to be appreciated. Therefore, the Refugee Convention was drafted to address the mass displacement caused by Second World War in Europe and has provisions for group or category, what we call determination. It could be the children category. It was the category which was exclusively addressing the rights of refugee women. It was what we call category of the elderly people. It was basically a category of the separated children. It was basically a category of the war refugees. Therefore, the 1951 Refugee Convention, UN Refugee Convention, has been perceived by states primarily as an instrument for individualized refugee assessment, and it is one of the most important, my dear friends, allegation that was leveled by the global South, what we call jurisdictions, against this Eurocentric convention when it was contemplated in 1951, immediately after the conclusion of the Second World War. My dear friends, individualization or the concept of individualism has always been very dear to the hearts of the European people. And that is why this idea of individualism and individualization of human sufferings and human problems is also reflected in the scheme or in the drafting of 1951 Refugee Convention. And because of this, pervading line of argument, the people on the other side of the globe, that is the global South, what we call jurisdictions, they never appreciated, they never bought this argument of the Western jurisdictions. And that is why initially it has been felt, even after the adoption of an additional protocol to 1951 Convention in 1967, the global South jurisdictions have been reserved. They never perceived, they never recognized the 1951 Convention as a international instrument on refugee protection. Therefore, individual assessments are considered inappropriate for mass influx, and some states, my dear friends, particularly from global South nation states, perceived refugee convention as inapplicable to situations of mass influx of flows. Then what should be done? How to proceed ahead from here? New instruments, my dear friends, new policies have been devised to bridge the gap between states' obligations of the non-refoulement and the requirement for a durable solution in situations where individualized asylum claims overwhelm the capacity of the state, what we call systems, or where the cause of flight is for non-convention reasons. I mean the reasons and causes which have been adumbrated in the convention have not been reflected in the human mobility or human flight. It is in this context, my dear friends, that the temporary protection has emerged as a regularized status in recent years. And this should not be what we call, forgotten. Because the temporary protection in its more recent formalized sense, or in a formalized or in a official what we call sense, takes a number of different forms in the area of world where it has been implemented and covers migrants or putative refugees fleeing various types of major crises in their home states. Thus, the temporary protection is generally known as by a set of the common elements. Number one element is temporary protection is a grant of protection of a temporary nature from the receiving state to a specific group or individuals. Number two, temporary protection is granted with the expectation that it is in the entry, it should be taken as an interim what we call solution, and at the end of the time period of the grant, the individual or the group will return home, or if return is not what we call desirable, either the receiving or a third state will offer more permanent what we call status for their rehabilitation, for their resettlement, for their assimilation, for their reintegration. Number three, temporary protection, my dear friends, may afford fewer rights to the individual receiving the state, particularly so far their status is concerned, than she would receive as a convention, what we call refugee. Despite significant, variables in these what we call submissions of mine, three important what we call points which I have submitted a moment ago. There is a common understanding what temporary protection entails. What does it convey? And the states have recently embraced it enthusiastically, my dear friends, for a number of what we call causes. The common understanding does not mean common agreement about the desirability or advisability of temporary protection in what we call many situations in which it has been used. Particularly, this reminds me of a very, very important, jurist on this particular, point, and that is, John, yes, let me recall. John Fitzpatrick, I think, who was of the view that the temporary protection, my dear friends, is like a magic gift. It is like a desired form that is likened by its what we call espousers. It basically should be taken as a policy objective. And at the same time, my dear friends, a temporary protection serves as a magic mirror of its observers. For refugee advocates, my dear friends, therefore the temporary protection expands the protection of the forced what we call migrants who cannot satisfy the criteria under the 1951 UN Convention relating to the status of refugees and its what we call promises and contemplation of the group-based what we call protection when the determination of an individual status proves what we call impossible. At the same time, we should not forget, my dear friends, that the refugee rights organizations fear that informal and discretionary temporary protection may dislodge refugee protection from the realm of enforceable human rights, and this should never be allowed to happen in the long run. Therefore, my dear friends, there are certain important advantages and disadvantages of temporary protection. From the perspective, viewpoint, standpoint of the state granting the status, temporary protection, or there are certain advantages of temporary protection. My dear friends, temporary protection, as I have already submitted, is a humanitarian response to situations of mass influx, whether towards persons who might qualify as refugees under the Refugee Convention of 1951, particularly the definition clause, or who would not qualify but are fleeing emergency situations in their home countries and deserves humanitarian treatment in their place of refuge. Temporary protections primarily offers, my dear friends, as one of the advantages, temporary protection offers an alternative to the receiving state's obligation to provide the full asylum procedures otherwise required for persons seeking refugee status, conserving what we call resources in often outstressed or overstretched what we call adjudication systems. Temporary protections, my dear friends, absolves receiving states from having to grant asylum to large number of putative refugees or palliating divisive domestic what we call political debates. Temporary protection at the same time has frequently been implemented as part of a consensus of responsibility sharing. Therefore, receiving or relieving any individual state of having to absorb the entire refugee flow involved, and temporary protection at the same time, my dear friend, displayed both to the arriving alien and to the what you call world at large. The state is providing protection not only or on the basis of what you call the temporary basis, with the understanding that this status will be resolved once the repatriation becomes very feasible. From the perspective of the putative refugees or potential what you call refugees, temporary protection has both advantages and disadvantages. Depending on a number of variables determined under the domestic piece of legislations, under the municipal estate practices, and generally when we are talking of advantages, there are, my dear friends, or in other words, let me put it like this: the individual is not required to go through protracted and often taxing asylum application procedures, the procedure that involved the completion of lot of formalities, a procedure that is very technical, that requires the fulfillment of the mandate that has also been contemplated and prescribed under the 1979 handbook that has been prepared by the United Nations High Commissioner for Refugees. Another important advantage that comes to my mind is that the individual may be granted many of the protection rights afforded to an asylee, such as the right to work, the right to freedom of movement, and the right to obtain certain basic benefits for or to eke out a dignified living in the society or in the country of reception. Another important advantage is that the status is granted for a definite period of time, allowing the individual to make specific plans for repatriation or for resettlement in the third country within a certain time frame that has been what we call contemplated in the temporary protection order. A proper or properly structured temporary protection program, my dear friends, can encourage states to allow access to their territory by ensuring, by guaranteeing, by ensuring that they will not be permanently and solely responsible for the imperiled persons that they admit. Frontline states, my dear friends, can condition the admission of refugees and refugee-like populations on the financial and resettlement commitments of the more distant states. They can also, my dear friends, enlist neighboring states in a coordinated response to the conditions that compel migration, as we have been witnessing in situations of Ukrainian refugees. The scope of a temporary protection program invariably depends on a state's definition of a refugee. Because 1951 Convention relating to the status of refugees with its additional protocol of 1967, my dear friends, contracting states cannot expel or return a refugee to territories where his life or freedom would be threatened on account of his race, religion, nationality, membership of a particular social group or political opinion. Therefore, the Refugee Convention represents a point of convergence by the international community on a humanitarian priority. This is the biggest what we call advantage of temporary protection. It has also, my dear friends, at the same time spurred the creation of a vast legal and operational what we call infrastructure to protect those, particularly those people who are likely to be the future what we call refugees or who happen to be at risk. Therefore, international bodies and refugee advocates fear that the temporary protection might be used to dilute refugee protections and reduce the likelihood that states will honor the legal guarantees which have been contemplated in the 1951 UN Refugee Convention. As per the European Union temporary protection directive, my dear friends, that should not be used to prejudice or prejudge refugee determination status in advance. Another important European Council, what we call, refugee, I mean, if there happens to be a regional non-governmental organizations, but recently it has been ever since its inception, and because of the work it has done in the area of what we call the refugee protection or in addressing refugee issues, it has already established itself as one of the most important what we call advocate and stakeholder so far refugee protection is concerned. So this is known as the Refugee Council, what we call refugee execution programs. This agency also, this regional what we call NGO also supports temporary protection only in emergencies when individual refugee determinations are not immediately, my dear friends, practicable, and when temporary protection will enhance the likelihood or the possibility of admission and territorial what we call protection. And this is one of the most important argument that has been advanced by this very regional non-governmental organizations, I think in the year 1997 or 1998. Whereas United Nations High Commissioner for Refugees perceives temporary protection as a stepping stone that can safeguard those in immediate, or that can what we call protect those in immediate what we call requirement until a more durable solution can be secured or found. Therefore, there have been various what we call experts, commentators, policy makers, and policy formulators who argue that the temporary protection, if used as a substitute protection, will impede ultimately the integration of refugees, or that may discourage to find out one of the options out of the three important durable solutions. Therefore, an analysis of the use of the temporary protection for refugees in Australia, Germany, Denmark, if you take into account, I mean, the last two important decades, you will find this concern has been advanced. And this analysis found, my dear friends, that those granted the temporary protection experienced social and financial difficulties, separation from family members, and a heightened sense of uncertainty and political what we call exclusion, and they have been suffering from a sense of precarity, I should say. Non-governmental organizations on many occasions, my dear friends, reported difficulties in meeting the needs of the temporary protection recipients for support what we call services. International bodies, on the other hand, are of the view that the temporary protection should have a firm legal foundation. Therefore, United Nations High Commissioner for Refugees, it starts from the fundamental principles of non-refoulement, including non-rejection at the frontiers. And this is a very, very important and solid point, my dear friends, that has been further what we call strengthened. And since 1981, United Nations High Commissioner for Refugees has been very firm on this fundamental principle, which is today known as the non-refoulement, and it has over the years has also attained as the status of the just cogence, or the one of the most important preemptory norms of international law, and it is equated, and that has been very, very liberally interpreted. At the same time, it has also been clothed and sheltered under the rubrics of what we call the customary international law. Therefore, the temporary protection programs typically rest on executive discretion, and consequently, they tend to be ad hoc. And that ad hocism, so far temporary protection is concerned, must be what we call discouraged, because the temporary protection is generally touted as an exceptional measure and a pragmatic tool to respond to the extraordinary circumstances of the mass influx of asylum seekers and its relationship with the 1951 UN Convention relating to the status of refugees with its additional protocol of 1967, my dear friend, has not yet been resolved, has not yet been established. Therefore, temporary protection was also raised in a number of international expert meetings in 2011 on climate change and displacement and international cooperation and burden sharing, respectively. But in But the declaration that has been what you call passed in 2016, which is famously known as the New York Declaration on Refugees and Migrants, ultimately came out with a novel idea of what you call of responsibility sharing or solidarity, what you call principle with the refugee hosting state, that ultimately established and created a very very important political space for international community to protect and grant all kinds of protections to refugees. And if you take into account the last 10 years, my dear friends, this reminds me of the month of July 2012. United Nations High Commissioner for Refugees organized a roundtable on temporary protection with the stated purpose to discuss the scope and meaning of temporary protection and to examine what it is or what it should be or what it does or should what you call guarantee and in what situation it could apply. While each of these what we call consultations and meetings raised the questions of the relationship between temporary protection and the 1951 Refugee Convention and accepted, my dear friends, the need for an adequate legal basis for temporary protection under international law. However, no consensus or consensus what we call view was forthcoming in this particular consultation program of the 2012. But temporary protection schemes are frequently justified by states as extra treaty measures and falling, therefore, within their sovereign discretion. The sovereign discretion, my dear friends, argument works in respect of the non-convention states or in respect of what we call granting of protection to persons who do not meet the definition of a refugee 1951 Refugee Convention. The sovereign discretion again is an inadequate argument so far my own understanding is concerned, my dear friends, because it permits the convention states from unilaterally suspending convention rights to convention refugees in situations of the mass influx. Therefore, if you take into account, my dear friends, another important, let me again take you back to the history, almost what we call more than 20 years back. In 2001, global consultations on international protection identified that a series of consultations which were organized to mark the 50 years of the 1951 Refugee Convention, temporary protection has an unclear what we call relationship with 1951 Refugee Convention, and one that has yet to be answered satisfactorily. Therefore, the beneficiaries of the temporary protection have in fact included, my dear friends, both persons who clearly qualify as refugees under the convention and others who might not be what we call qualify or might there is no possibility of their what we call qualifying. Therefore, the global consultations confirmed the need for greater what we call clarity that is relating to the scope of the international protection in situations of mass influx. Beyond its legal what we call basis or the legal mandate and the appropriate use of the temporary protection, United Nations High Commissioner for Refugees, the European Council, and other important regional NGOs also broadly agree on the structure and characteristics of temporary protection programs, which are having the idea or they have disseminated the idea of the limited duration, timely access to refugee or asylum what we call determination, right what we call proportionate to the duration of what we call of status, access to justice including the courts and administrative authorities, then the non-favorable treatment due to unlawful persons, and the family idea of the family unity, and availability of the right to education, a right to eke out a dignified existence. So these have also been the main what we call features of idea of temporary protection. And this reminds me of another important what we call dimension, and that is range of rights. My dear friends, idea of temporary protection may be limited in understanding. It may also have a very, very limited application in the context of the range of rights that has been made available to the refugees under 1951 UN Convention on Refugees. But there are certain important non-derogable rights. Non-derogable rights are those rights which are absolute rights. Rights which cannot be compromised upon. The rights wherefrom no reservation, no exception, no limitation, no conditions, no riders are permitted. It means we cannot limit those very rights. Suppose right to life, right to human dignity, right to have cognitive freedom, right to mental continuity. These are some of the important non-derogable and absolute rights, wherefrom no preclusion can be permitted. Therefore, if you take into account the current or contemporary canvas of temporary protection, my dear friends, then there are basic necessities like food, shelter, and health care, which have been guaranteed by the United Nations High Commissioner for Refugees note issued in 1981. Then again, employment to promote self-sufficiency. It is the European Council, what we call, directive of 2001. Another important, what we call, requirement, that is the identity documents and residence, what we call, permits, which have to be granted to the, refugees in situations of, mass influx in the context of, temporary protection. My dear friends, we cannot compromise upon the ability to obtain visas, and only narrow restrictions on movement could be contemplated. Protection of minors and unaccompanied, what we call, children. Permission to send and receive what we call, communications, mails, correspondence. And registration of birth, death, and marriages. That has to be what we call extended in situations or in the form of granting temporary protection, and burden sharing by states, including in establishing durable solutions. As per the soft law that has been agreed upon in the form of what we call of New York Declaration of the 2016 on refugees and migrants, that must also be taken into consideration in the form of responsibility sharing and removal of causes of the large scale influxes and establishment of the conditions favorable to voluntary repatriation. My dear friends, like refugee status, temporary protection can be withdrawn when the conditions giving rise to it are no longer available. A recent United Nations High Commissioner for Refugees roundtable concluded that the termination of the temporary protection should occur only when return can be carried out in safety and dignity. The recipient has, transitioned to another what we call status. Protection responsibilities have transferred to another state, or the individual finds a durable solution. Repatriation, my dear friends, must not be forgotten. And repatriation under all circumstances must be structured so that it does not contribute to further instability in the community of origin or in the country of what we call of origin. European Council holds that the return should take place only on the basis of an independent and impartial human rights assessment in the country of origin. And moreover, the voluntary repatriation may be more successful when the right to work, housing, health, family, reunification, and education, or right to education, have been honored in the what we call host nation states. Therefore, my dear friends, it is equally important to understand that the refugee protection and asylum, what you call, systems, how these have been, functioning in some of the most important, nation states. So individual nation states functioning becomes very, very important. And we have to understand how idea of temporary protection, idea of refugee protection, idea of, extended a range of rights to refugees and asylum seeker has been or have been functioning in many what you call European nation states as well as in United States of America. So that has to be taken into consideration because this is very, very important. What has been the state practice so far? These nation states are concerned, and at the same time, we should also try to understand what has been the state practice so far hosting of refugees is concerned in South Asian nation states. I will continue. Thank you very much for the day. Any questions? You're most welcome.
No, sir. Thank you so much.
Thank you very much, ma'am.
Thank you, sir.
You're welcome.
Thank you, sir.
Sir, though I did recall something, it's not related as much, but with the Ukrainian and Russian war which is going on, and I recently read that US has been giving refuge to Russians and Ukrainians while expelling the other refugees that are already there, like from Haiti or Central America. So, sir, is it just because it's a European issue and being Eurocentric, um, or is there anything else involved? I don't get why is this happening?
It is very much related, and it is a very, very important question. At the same time, it is highly controversial as well. And thank you very much for asking such a paradoxical inquiry. It is, or rather, I should say, regardless of any kind of a consideration, Miss Sajul, we can have different nomenclatures, different adjectives to qualify the idea of protection. But in the ultimate analysis, when we are talking of refugees, we are basically talking of their protection. Forget about whether it is a temporary protection, surrogate protection, substitute protection, temporary protection, or any other kind of protection. Forget about all forms of protections. And what remains to be understood is the preservation and promotion and fostering of rights of refugees and their protection. And your question is of vital importance, but I should not confine your question to America alone. This is a question which is having global ramifications. This is a question which can be attributed to the state behavior of all geopolitical entities. This is a question which basically cajoles the dirt in the civilization, as Cicero has rightly pointed out long back. Scratch the civilization and you will find dirt. That kind of a question you have asked that ultimately agitated, and that is bound to agitate juridical proclivity of each and every sensible person. In refugee influx, particularly the Ukrainian refugee influx or the mass Ukrainian refugee influx situation, what we have been receiving, not only they have lost the national protection of their country of origin, that is Ukraine, because of violence, because of armed conflict, because of aggression. The word aggression or because of the foreign occupation. Unfortunately, the framers of 1951 convention could not contemplate these grounds. But these are the grounds which have been contemplated by the African Union Convention, which is popularly known as the 1969 OAU Convention governing the specific aspects of refugees in Africa. These two elements, the generalized violence, armed conflict, foreign aggression, foreign occupation, foreign domination, are the grounds in the definition clause under Article 3 of 1969 OAU Convention on Refugees. But the collective wisdom of the great civilization like Europe, they could not contemplate these grounds. But these grounds have become important in the ongoing confrontation between, or the ongoing armed hostilities between Russian Federation and Ukraine. The point, again, I am taking back the points which the question that you have raised, ma'am. That question is also having some multi-layered conflations, a multi-layered human rights violations miasma, and that is racism, that is jingoism, that is white supremacy, that is white autochthonic assertions, where that is the idea of exclusionism, where we have been witnessing racial chauvinism, where we have been witnessing the idea of what we call of religious hate, religious supremacy, supremacy of the Christianity. This is what we have been witnessing in the mass influx situations of Ukrainian refugees. I never intended to deliberate these kinds of points, but since you have asked this question, it becomes necessary to respond to your question. And you have rightly pointed out that the United States of America, State of Israel, European nation states like France, Britain, they have already done what we have been witnessing on the part of the Russian Federation in Ukraine. We are having examples of international interventions in the name of human rights, in the name of democracy, in the name of what we call the international rule of law. But it was basically the American interest in Iraq, in Lebanon, in Rwanda, in Afghanistan, and other parts of the world. Russian Federation is doing nothing new. But my dear friends, particularly ma'am, aggression and bombardment of the global South nation states has always been a new normal in the post-Second World War era for global North jurisdictions. Now they have started what we call, otherwise, see the pictures of Syria, Syrian cities, Yemen, Yemeni cities, Rwandan cities, Afghan what we call cities. Now we cannot distinguish who is Afghan city or a Syrian city or the Kiev what we call as a city, or Ukrainian cities. But unfortunately, we are not learning as a nation states. We are not taking enterprising and corrective and reformative measures or lessons from this what we call armed conflict debacles in different geopolitical entities. United States of America today is considered to be a land of migrants. Canada is considered to be a land of multiculturalism. United States is considered to be a land of diversity, human rights, democracy, rule of law, judicial review, affirmative action. but these what we call fundamental principles which make America to espouse the cause of American exceptionalism, ultimately what we call ravages this particular doctrine of American exceptionalism to the ground. And therefore, we can say, Ms. Sajul, when we are talking of American values, particularly American constitutional values, these values are exclusionary, discretionary, and discriminatory. And this is not at all reflected in the behavior of the American state as a nation state, because it is also suffering from the white supremacy. And this jingoistic idea of white supremacy is nothing but it reminds us of of the decisions like Dred Scott decision that was delivered in 1854 by Justice Taney under the same what we call constitution. So there is a emergence of the a right-wing nationalism in United States of America. There is a emergence of the right-wing what we call nationalism in many of the European nation states or European nations or European geopolitical entities, which are ultimately underestimating. Indians have been discriminated in Australia, in New Zealand, in Ukraine. They have been pushed what you call aside when the people, I mean the Ukrainian refugees, were boarding trains and buses. They have been pushed to the background, and instead of them, instead of maintaining any kind of a civility in the queue, they have what you call given room for the white what you call refugees. Same is happening in United States of America. I can give you another important example, Ms. Sajul. When during the Trump administration, two people who fled Ghana because of their being gay, they took shelter rather, I should say, in United States of America. But because of the state behavior and the behavior of the law enforcement agencies, they were having apprehensions. They would be apprehended for because before their what we call apprehension, before their what we call being apprehended, they immediately what we call fled and crossed into neighboring Canada, and where they have been what we call living. So the right-wing nationalism has created a lot of problems in many of the what we call geopolitical entities, and it is nothing new. There is nothing new that the United States of America is behaving like this, because if you go through the history of the black people in United States of America, then you will find umpteen number of what we call examples. History is replete with this kind of examples where you will find that there has been a naked dance of what we call of the white supremacy. And recently, a movement that was there because of the Floyd's death, black what you call life matters or black rights matters. This movement is still kicking and thriving in the United States of America. But we cannot blame the Constitution and the law of United States of America, because application of law depends upon the legal mind and juridical thinking. Instead of applying the Refugee Act of 1980 of the United States of America, number one, instead of applying Immigration Act of 1964 of United States of America, Trump administration has applied Immigration Act of 1924, a very obsolete, archaic, and redundant piece of legislation passed by the US Congress. They haven't what we call applied the latest what we call legislations. And unfortunately, majority of the international human rights conventions have been what we call discouraged, and United States of America has not been privy to major international human rights treaties. That is why we have been witnessing a sense of what we call of or rather a practice of unilateralism in the behavior of the United States of America on such issues. Though on the next occasion, I would begin my submissions from here, and I would also tell you that on many occasions, United States of America has also came forward to host refugees. Suppose I can give you an example. In 2012, United States of America admitted more than 60,000 refugees in a single year. In 2014 alone, ma'am, United States of America admitted more than 70,000 refugees. US has also provided political asylum to nearly, or rather I should say, more than 30,000, I mean, asylum seekers. US has also granted withholding of the removal in more than 1,910 cases. US has also granted relief from removal to more than 500 persons who would likely, or who would otherwise, I should say, have been tortured if returned in their country of nationality. Under 1951 UN convention, my respected students, even the states cannot expel or return a refugee to a territory where the life of refugees, the future of asylum seekers, or their freedom would be threatened on account of their race, political opinion, region, their membership of a particular group, or any kind of ethnicity. So therefore, individualized refugee determination for person outside the United States of America, and particularly political asylum adjudications, particularly for those within the United States of America, exclude vast categories of persons in genuine what you call peril. So there have been instances, particularly most notable presidency in the recent years has been of the Obama presidency, where we find even the United States of America under President Barack Obama has also what he call doled out financial assistance to countries like what he call Bangladesh, countries like Malaysia, at least $1,000 per what he call refugee. If I am not what he call correct, if you find, and let me check this particular figure again, but this has been the behavior, I mean this has been the policy, this has been the what you call assistance, humanitarian assistance that has also came out from United States of America. Yes, Mr. Omja. Yes, Ms. Sajul, would you like to supplement further?
No, sir. Thank you so
Yeah.
much.
Yeah, you're welcome. Yes, Mr. Omja.
Sir, I'll reframe my question like in the next class, because like I'm not like I've forgotten my question.
It's okay. It's
So
okay.
it's a very interesting question actually. So I'll pose it in the next class on Monday.
Yeah, definitely. Most
I think, sir,
welcome.
sir, whereas as far as I remember, it's with regards to international relations and politics. So I just want to.
Yeah, please frame and formulate your question. I would love to answer it.
Yes, sir.
And I do not, as you know, I never advocated, I do not believe in any kind of a one-way traffic in my classes. The classes should be very participatory, vibrant, and interactive. Then only we can generate some kind of a consensus, some kind of a intellectual outcome that is having some innovation, novelty, and some newness. Yeah, thank you very much. Thanks a lot for being with me. Wish you all the best. The day is still young. Enjoy yourself.
Thank you so much, sir.
Thank you. Thank you very much.
Thank
And
you,
thank you very
sir.
much once again for joining me for this class. Thank you.
Thank you, sir. Have a good day, sir.
You're welcome.
Have a good day, sir.
Same to you. Thank you.